Looking at the sort of the subject of the panel, or obviously realising my colleagues are going to be talking in detail about the European process at the moment, I thought I'd sort of address some of the principal issue and also provide maybe an alternate view, because there are many things that are going on. It is my position that data protection, of course, is a great thing, an absolutely essential thing, and that, like Judith said, I think we've broadly speaking got the principles right. The instruments that we have, the mechanisms, the means are obviously difficult. What we have in this country, certainly, and probably in other countries as well, is unfortunate sort of difficulties with the way the legislation comes about and a culture that starts to emerge. The former Information Commissioner Richard Thomas used to talk about the fact that he had less than the price of a Mars bar with which to regulate the use of every citizen's data in 1 year. What we got instead is a bit of a sort of emergent health and safety culture, people being a bit risk averse about doing stuff with people's personal data, and that not being helpful on both sides. My position is that this is a fundamental thing. In information society, things which are done to my data affect me. Therefore, I am the person who should be in control. Without that control, I cannot exercise my right to determine who does what to my data. In that case, I would not have the ability to exercise my human right to privacy. So, we're looking at something that's going on at the moment, and it's framed in terms of data protection. The language around that, I think, is outdated in many ways and semantically incorrect. You are the data subject, sorry, and someone else is the data controller. By subject, actually, largely we're talking about you being the object and your data becoming the commodity. Yeah? Let's look to possible alternatives. This is radical, by the way. This is not. I'm not mucking about it. This is something we've been developing as a proposition with the sort of policy, technology, legal interface now for some years. It's an idea, a new idea that we call informational privity. So we're used to leases of real property or licenses of copyright that occurs through a chain of contract. Those contracts, each of which give specific and limited rights to the recipient of the contract. And they also give no rights to people who don't have a contract or who are outside the chain. And on that basis, it's clearly natural that someone who has rights can get direct redress against someone who infringes those rights. Yeah? Someone who has no rights to their data, or someone lower down the chain who exceeds the rights that they have. So we're talking about something, an idea, that would be akin to an enforceable property right that has some of the features of confidentiality, but extended to the use of all personal data. And we get very careful you're not talking about ownership, because that leads to all sorts of traps. If transfers of personal information were subject to such a right, and get your head around this, and functionally constrained by it, and could not be casually waived by contract, could not be handed away by a tick box at the bottom of 42 pages, then we would have the means to build some conceptual, technological structures that would allow us to discipline the use of our data. But what does this do? Why is it so controversial? Well, it's controversial precisely because it gives the individual, not a regulator, not post facto enforcement, but the individual, the ability to assert their own rights, and it can be developed in the courts. Yeah? It doesn't rely on the foresight, vigilance, or the funding of the regulator. And of course, personal rights are a lot harder to politically interfere with than the scope of statutory bodies. So, we contend that this would be, the net result of somehow this would be a better data protection, and almost certainly better privacy. So, that's just another idea. It's further out there. It's not something that we're talking about. It's not what's politically in front of us at the moment. But if we don't have these ideas, if we don't talk about these principles, if we don't actually go for the sorts of things that are much better, much clearer, ways of us managing our own data within the information society and information economy. We might get denial of service attack, we might get drowned in the bureaucracy, drowned in the very red tape of the machinery that's supposedly protecting us at the moment. Machines, building technology that will allow you to exercise these sorts of rights right now. So we should not just be looking at, let's get it fixed somewhere over in Europe and hope that gets well implemented into our own law. This is clearly going to be a long-term process and an ongoing negotiation. Let's take a little bit of responsibility for managing our own data and using those vehicles which provide us with those mechanisms within the law, whether it be data protection law, contract law, or what have you, and start to take a little bit more responsibility for our own personal data and what permissions we give to others.